Since 1992, felons have been prohibited from being in possession of a firearm as related to the Gun Control Act, a federal law. 1992 is when the ATF stopped taking applications to restore somebody's federal firearm rights. Now things have changed. Now the Department of Justice just recently issued its proposed rules to reboot this program. No longer is the ATF going to be doing this program. Now it will be the Attorney General, and they are expecting 1 million applications in its first year. When we look at the new rules, now they define who is going to be accepted in this program and who are not. There's a number of felony offenses that are going to be permanently excluded. Those are traditionally assaultive crimes and crimes against a person, arson, assault felony cases, burglary, home invasions, felony firearm-related offenses, and felony domestic violence offenses. Those offenses are permanently excluded unless there's extraordinary circumstances. So even if you have an armed robbery on your record, if we can demonstrate extraordinary circumstances, we still can be successful with an application to the Department of Justice. Then there are 10-year offenses, misdemeanor domestic violence, and controlled substance offenses, delivery and manufacture offenses. There's a 10-year waiting period. You have to wait 10 years after completion of the sentence before you're eligible. And then there's 5-year offenses where you have to wait 5 years after completion of the sentence. And that's basically any other felony other than the excluded offenses and the controlled substance or domestic violence offenses. The program now expands the approach that the department will take when considering these applications. It is significant. They are going to look at a lot of different things. They're going to look at even offenses that have been dismissed as part of a plea bargain, or even the facts of cases where they were never charged in the first place. This is a much larger scope that the program is going to look into in order to determine whether somebody has a reputation for dangerousness. The documentation that are going to be necessary for these petitions is going to be much more expansive. We're going to have to now get police reports for every conviction offense and for offenses where somebody may not have been convicted or even charged. They're going to take into consideration the facts of every single situation and every single case. We're going to have to get pre-sentence reports for every offense for which somebody was convicted. We also are going to have to notify the chief of police or the chief law enforcement official in the municipality or jurisdiction in which somebody lives. This is an example of how comprehensive this petition is going to be, how much work it's going to be necessary. But when somebody puts in that work and somebody provides all of the necessary information, a great case can be made that somebody's reputation for dangerousness no longer exists to the degree to which that they are now deserving of having their Second Amendment rights restored. Now, there's always been this opportunity to restore people's state firearm rights. That gives people the opportunity to possess a firearm, perhaps in their home or at their place of business. But the federal prohibition, 922G federal prohibition, kept those felons from buying and purchasing firearms from federally licensed firearm dealers. And a state firearm restoration didn't prohibit the federal government from prosecuting felons for being in violation of 922, which is being in possession of a firearm by a prohibited person. Now we know with these rules having been published that the federal system is just on the horizon. Pursuing a state restoration is going to help that federal process. And we know what those conditions are looking like. And so getting started on a federal restoration petition is a great idea to do so immediately. The next question is, when can we begin preparing these petitions and submitting them to the Department of State? Right now, we're in this 90-day waiting period for comments. The proposed rules have been published, and there's now the opportunity to send in comments about what people may think about those rules. Then, after the comment period is ended, there's going to be a public hearing, after which then they will modify these rules and publish them and publish the final version. Then there'll be a period of time between final publishing of the rules and acceptance of applications. But we are advocating getting started on this now, getting started putting together these documents and putting together this petition now, because we're not going to wait until they begin taking applications to begin putting together the petition. A good petition may take months to get together. And so let's get started now. Now we have the rules, we have the parameters of which that they are looking for, the things that they are looking for. We can start putting together these things now, and that's what we're going to do. The Second Amendment of our United States Constitution is an incredibly important right to so many people. Their right to bear arms has been taken away from felons, people convicted of a felony 5, 10, 20, 30 years ago even, which shouldn't and doesn't define them today. Now, those individuals can demonstrate and prove that they are no longer dangerous individuals and have the right to be able to exercise, just like everybody else, their right to carry and possess a firearm in order to protect themselves, protect their family, or simply just possess a firearm because they want to. These are individuals, many of whom are no longer dangerous. They're completely different, and they shouldn't be treated as second-class citizens. Now we have the ability to restore those rights so they can be treated just like anybody else in this country because they deserve it.